Alrighty.
All right, good morning. This is Nima Ghazvini. I'm the Chapter 13 trustee appointed by the U.S. Department of Justice, Office of the United States Trustee to oversee the administration of Chapter 13 bankruptcy cases in the districts of Hawaii, Guam, and the Northern Mariana Islands. Going to go over some basics of bankruptcy practice with a focus on Chapter 13s. And the examples and forms that are going to be used are either national or the ones specific to Guam. So first, what you'd like, oh, whoops, how do I go to the next page? I think we're going to go in this order, pre-filing considerations. We're going to go over the different chapters available to debtors and some things you may want to consider in deciding which chapter fits the needs of the potential client. The petition, schedules, statement of financial affairs, and the Chapter 13 plan, which are all national forms. And then the Chapter 13 plan, which is a form adopted by the Guam court. We'll touch on the meeting of creditors, confirmation hearing, and some things to keep in mind for post-confirmation considerations. I also want to say that I'm completely open to questions. It'll probably help me understand where you are in your practice so I can focus more on areas that are more relevant to you. So I think what you want to start with is which chapter best benefits the debtor's needs in case if you are representing the debtor and you're deciding which chapter to file the petition under. So I'm assuming that most of the folks that walk in through the door are going to be individuals who are having a hard time with their debt. In this case, the bankruptcy code will present some solutions to the debtor's mounting debt problem. As far as consumers go, and those are individuals with consumer debts rather than commercial cases, you're looking at Chapter 7, 13, or 11. The Chapter 7, you're going to be, Chapter 7 can be commenced with a voluntary bankruptcy petition or an involuntary bankruptcy petition. That's because 3 or more creditors can force a Chapter 7, can file a Chapter 7 petition. But what your clients are looking at in a Chapter 7 is walking away from their debts, but also walking away from their assets. In a Chapter 7, a trustee is appointed to analyze the debts and potential assets for liquidation, and if the liquidation of the estate will provide a dividend to creditors, then they'll move forward with the liquidation. In a Chapter 13, on the other hand, the debtor remains in possession of their assets and is in the driver's seat, basically. They're going to put forward a reorganization plan. Chapter 13s are always voluntary, and that's important because at any time that an individual has second thoughts or sees things not going their way necessarily, they will have the absolute right, near absolute right, to dismiss their case. I'm going to go back. Chapter 11 is typically for corporate restructuring, but some individuals may find themselves in Chapter 13. These are going to be typically individuals with a higher amount of debt than they're permitted to have in a Chapter 13. So with the filing of the bankruptcy petition, you're going to be dealing with, obviously, if the debtor, if you are representing the debtor, potential creditors, attorneys for each, the debtor, the creditors and the trustee, the bankruptcy court, bankruptcy judges, and the United States trustee. The United States trustee in a Chapter 13 has a supervisory role. They are not as involved as they are in the other chapters. So in a Chapter 13, you're typically going to be dealing with the Chapter 13 trustee, Chapter 13 trustee's office, and their staff. As of today, the office administrating cases in Guam is located in Honolulu. And we have many staff members. We have an attorney on staff. We have a manager of operations. You have Ms. Veronica Valdez, who's the lead paralegal, and several claims analysts and case analysts. Typically, if you need assistance or if you have questions about cases, we're here Monday through Friday, regular business hours, with the exception of federal holidays. So a Chapter 13, you may be wondering, okay, in a Chapter 7, my client can file bankruptcy, not pay anything to creditors, and walk away debt-free. And that's true in a lot of cases, but there are some consideration you may want to discuss with your clients. So when in Chapter 13, you typically, if you show you have the means to, can keep your assets, you can retain your property. So that's usually, for most folks, that's their home, car or cars. You know, they can continue to operate their business if that's their source of income. They can pay back non-dischargeable debt if they can, even if they have non-dischargeable unsecured debt, they can still use the Chapter 13 plan as a repayment plan. And in a Chapter 7, you're looking at a discharge of your dischargeable debt, which is going to be the non-priority unsecured debt, but you really don't have an opportunity to pay back other debts. So these are some of the benefits of 13. What makes an individual, well, what makes someone eligible for 13 relief? First and foremost, that person has to be an individual. So you can't have any business entities or other types of entities filing a Chapter 13. The Section 109E of the code defines who may be a debtor, and 109E specifically touches on requirements for Chapter 13 debtors. As of now, the 109E has certain debt limitations. So from now until June, unless the law changes, the debt limit remains $2.75 million, combined secured and unsecured. Unless the Congress decides to extend that, it'll revert back to the old statutory scheme. So you'll have a split of secured debt limits and an unsecured debt limit. Prior to the current temporary law, the debt limit was approximately $1.4 million for secured debts and approximately $400,000 to $500,000 for unsecured debts. So secured debt, that you're looking at your home, cars, anything that's secured by collateral, any debt that's secured by collateral. For many individuals, that means that if they have a mortgages that total more than $1.4 million, they may not be eligible for Chapter 13 relief. Same for unsecured debt. So if you have tax debt, student loan debt, credit card debt, and any other type of unsecured debt that exceeds $400,000 to $500,000, then you may find that that individual is not eligible for Chapter 13 relief. And so that individual will be forced into a Chapter 11 or Subchapter 5 case. That's why I put the Chapter 11s in the as one of the chapters available to consumer debtors in an earlier slide. The reason I'm giving you a range of debt is because the debt limits increase periodically, and I have no way of knowing what that debt limit is going to be coming up in June. Again, currently, temporarily, the debt limits were raised to $2.75 million. This was a sort of a COVID relief time when the Congress was passing all sorts of laws because of the pandemic, and this was raising the debt limit was supposed to be allow more people to benefit from Chapter 13 bankruptcy rather than force them into Chapter 11. But again, unless Congress decides to extend that, then it'll revert back to the old statutory scheme. A debtor may not be an individual for bankruptcy relief if they have had a prior case dismissed within the past 180 days. You're going to take a look at 11 U.S.C. 109G to see if your client may not be eligible for Chapter 13 or any other bankruptcy relief based on a prior dismissal. And lastly, this is one of the requirements from the change of law in 2005. The debtor has to receive a qualified pre-petition briefing. So there's many agencies that provide this, pre-bankruptcy filing certificate. You want to make sure that your client receives that briefing from a qualified provider before the bankruptcy case is filed, and you're going to file that certification with the bankruptcy documents. So I'm going to go over some of the bankruptcy forms. There's just too many to go over right now in the time we have. So I'm just going to highlight some of the forms and some sections of the forms. If you have any questions, please let me know, or you can also email my office after the presentation today. But basically, you begin with a bankruptcy petition. That's how every bankruptcy, a Chapter 13 bankruptcy is commenced. And you begin with selecting the district and the chapter you're filing under. You want to go with full name for debtor 1 and debtor 2. Debtor 2, so if you have a client that's married, then their spouse, you can add their spouse to the case and they can file a joint petition. But that's the only way a joint petition can be filed. Otherwise, each person has to file their own petition. I also want to point out at the top right, there's a box that says check if this is an amended filing. And this is, you're going to find this box on all the bankruptcy forms, including including the schedules and statement of financial affairs, and basically any form you file in bankruptcy. And that's because you're going to be filling out so much information. You may not get it right the first time, and the errors might be pointed out to you by the Chapter 13 trustee or another party. You're always free to file an amended filing. So I guess what I would say is that don't be afraid to file a bankruptcy petition. Don't be afraid to make a mistake or errors. You can pretty liberally amend schedules or any other document that needs to be amended later on in the case. Section 5 of the petition, this is something I find is often problematic with cases filed in Guam, and that's the mailing address. Typically, we have a lot of mail return because the mailing address isn't correct. You want the court and other parties and the Chapter 13 and the trustee's office to be able to contact your and give notices to your clients of what's happening in their case. And the only way we can do that is by mail. We want to make sure that the mailing address is correct. So at the top here, you have where you live, because that's also important. We need to the creditors and all the parties are entitled to know where the debtor actually resides. But if the mailing address is different, then you fill out this second or the lower portion of the box too. Another and keep in mind, with a Chapter 13 filing, you're looking at a case that may last anywhere from 3 to 5 years, and it's very conceivable that clients will move during that time. If your clients move or they have a new mailing address, there's no necessity to amend the petition again. You can file a change of address form with the court. The form you file with the U.S. Postal Service to change your address or to forward your mail, that doesn't change anything with your bankruptcy case. You actually have to file a different form to change your mailing address with the court. And that goes for attorneys too. You're going to be served with documents from the U.S. Trustee's Office, from the Chapter 7 or Chapter 13 Trustee's Office, notices from the court. You want to make sure we have a correct address for you at all times. The first of the schedules is Schedule AB, and this is where an individual who's filed bankruptcy is going to disclose everything they own. And if I can give any advice, is to be in filling a Schedule AB, that's to be overly inclusive. You don't want to look like you're hiding anything. Please obtain, you should have some reasonable justification for the value of the property. Otherwise, it's just going to raise red flags for the trustee's office. So in this case, part 1 is real property. You want the full address so that the property can be searched. Not searched, like there's not a search party or anything, but so that the records and stuff can be, the trustee's office can look up the records related to that property. Describe the nature of the property. Is it a single family home, a duplex, condo, manufactured, or mobile home, land? And who has the interest in the property? Is it just the individual filing the bankruptcy, debtor 1? If the case is being filed as a joint case with your spouse, is it just debtor 2, or is it debtor 1 and debtor 2? That could have impacts on what type of plan is ultimately confirmed. The current value of the entire property, typically you want to look at tax assessed value of the property. If you don't find that to be accurate, you may want to look at other source of obtaining a value. Some courts require a broker's price opinion or other type of evaluation, but that's not the case in either the Guam, Hawaii, or Northern Mariana Islands courts. And then describe the nature of your ownership, because that goes to that information is necessary again to evaluate your Chapter 13 plan. One of the most important sections of the Chapter 13 of the Bankruptcy Code is the trustee's evaluation of whether the plan proposed meets the best interest of creditors. You want to take a look at Section 1325A4 of the code. So if in a hypothetical liquidation, a Chapter 7 trustee can liquidate your assets and pay more to your creditors than you are offering to pay in a Chapter 13 plan, well, then your plan can't be confirmed. So you always have to pay your creditors at least as much as they would receive in a Chapter 7 liquidation. So what does that mean? If you own a home free and clear, no mortgages, no encumbrances, say it's a $300,000 home, well, you can take into account the liquidation cost of that home. So you're talking about the broker fees, the closing costs, escrow fees. You can also take into account the Chapter 7 trustees fees. But let's say after 300,000, from a $300,000 home, after all the fees are paid, you're left with $250,000. Well, then that $250,000 is the amount that would be available to your creditors if the state was liquidated in a Chapter 7. So in your Chapter 13 plan, you have to make sure that the plan payments are enough to pay your unsecured creditors at least as much as they would get in a Chapter 7. So if you have $200,000 in unsecured creditor claims, then your Chapter 13 plan has to pay that amount in full, right? Because in a hypothetical Chapter 7 liquidation, creditors would get up to $250,000. You have $200,000 in debt right now, according to your schedule. So your plan should pay at least $200,000 to unsecured creditors. Now, let's say let's say the liquidation would not yield $250,000, but would yield $50,000. And that $50,000 would be available to pay your unsecured creditors in a hypothetical liquidation of your assets. And you still have, and the same debtor, it's the same debtor, and that debtor has $200,000 in unsecured debt. Well, then your Chapter 13 plan has to pay at least $50,000 to your unsecured creditors, or approximately a 25% dividend. You can propose a plan. If you're not used to proposing Chapter 13 plans, if you're not, the worst that can happen is that somebody will object and say, no, this doesn't meet the requirements of the bankruptcy code, okay? And then the objection will state the plan has to raise payments to this amount, or, A, B, and C needs to happen. Nothing catastrophic is going to happen as long as you're following cases in good faith and you're making a good effort. Because you'll be given an opportunity to amend the plan, or you'll be given an opportunity to make your case about why the objection's incorrect. And if worse comes to worse and the outcome is that the judge rules, no, the trustee's right, or the creditor A, B, and C are right, and the plan should look differently, and the plan is not confirmable, then remember, you have the right to dismiss the case. So again, I think that's one of the reasons I think Chapter 13 is great, because it gives you an opportunity to deal with your debt, but it doesn't necessarily lock you in. Whereas in a Chapter 7, you don't have an absolute right to dismiss the case. Once you file that Chapter 7 case, the Chapter 7 trustee is appointed and they go to work. Schedule C is, so remember, Schedule AB was where you listed all of a debtor's assets. On Schedule C, you'll list these same assets, and you can see how it refers to Schedule AB, line from AB. Same descriptions, the value of the property, but also here's where you get the opportunity to exempt it. There's every jurisdiction has a set of exemptions. You may refer to Section 522D of the Bankruptcy Code to see the federal exemptions. But basically, the idea is that you can keep some assets free of, out of the hands of the trustee or your creditors, free from their reach. It's just that there are specific dollar limits to that, and those are stated for the federal exemptions. You want to look at 522D to see what those dollar amounts are. So, for example, you can again, going back to that example where we have a $300,000 home. There's no mortgages against the property, and you want to take advantage of an exemption you're entitled to, well, you can use that dollar amount exemption here, and then that will decrease the value of the estate in a hypothetical Chapter 7 liquidation. Let's say you have a car you want to use, and you own the car free and clear, or you owe very little on the car. So you then list your asset, the car, the code section that permits an exemption of some or all of the value of the property. And therefore, again, it's out of the reach of the trustee and your creditors. So then that car's value doesn't come into account in a hypothetical Chapter 7 liquidation. You can expect the Chapter 13 trustee's office to review the Schedule C carefully to make sure that you've taken exemptions that A, the debtor is entitled to, and B, that are available to you in your jurisdiction. If not, then you can expect an objection to the claim of exemptions. That will get set for a hearing. And again, you have the opportunity to amend Schedule C, just like you have an opportunity to amend any other documents. Schedules D, E, and F is where you will list all creditors based on their classification. So with Schedule D, you start with the list of secured credit claims. So this is going to be your mortgages, cars, anything else secured by debtor's property interest. Notice here that you can mark a debt as contingent, unliquidated, or disputed. You may whether you mark it as disputed or not really doesn't have that much bearing in the ultimate confirmation of your plan. But if you find your client is near or past the debt limit in a Chapter 13, then you may want to review their debt to see if any part of it is contingent or unliquidated, because contingent and unliquidated debt does not count towards the debt limit in a Chapter 13. But if you're marking it without a good reason, then you can expect an objection that says that you did not file the schedules in good faith and that your actual debt limit is higher, that your debts do exceed Chapter 7, Section 109E debt limits. So this is Part 1 of Schedule D. Moving on to Schedule EF. Schedule E and F are your unsecured claims. You begin this form with a list by listing debtors' unsecured debt, but specifically priority unsecured debt. These are debts that are entitled to priority under the bankruptcy code and are not dischargeable. Notice I'm going to go back one slide here. You describe the property, and then you'll be asked to it's cut off here, but you're going to have to mark who owes the debt and the nature of the debt. Here you have, again, the same questions. So you list the creditor and the creditor's address and who incurred the debt. You can, again, mark it as contingent, unliquidated, or disputed. Oftentimes people leave all three blank. But you also mark the type of priority. So domestic support obligations like child support or alimony or any other type of court-ordered obligation that's characterized as domestic support is one type of priority unsecured claim. Tax debt is oftentimes a priority unsecured claim, and not necessarily in its entirety, but at least a portion of it. And claims for death or personal injury while you were intoxicated. The last 4 digits of the account number are really important because if your plan is ultimately confirmed, this is how we'll verify and administer which claims filed by creditors match up with with the debt that you scheduled. The total claim amount is pretty self-explanatory, but the priority amount is going to be the non-dischargeable portion of the claim, and the non-priority amount is one that can be discharged at the completion of your plan. In Part 2, this little section. It's basically the same thing as part one, where you listed priority unsecured claims, but now you're going to list your general unsecured claims. So this is going to be mostly your student loans, credit cards, and other debts. And even though student loans are considered general unsecured claim or non-priority unsecured claim, they are still non-dischargeable by operation of the bankruptcy code. Fast forward to schedules I and J. I didn't go over G, which is going to be your leases and executory contracts. So car leases or any other type of contractual obligation. That's where you would list that type of debt. On Schedule H, that's where you list names of co-debtors and that's assuming that your co-debtors are not parties to the case. So if the debtor has a brother or a family member or a friend who is a co-debtor on any of his or her claims, you want to list them on Schedule H. Schedule I is, for purposes of a Chapter 13, is where I look to see whether your client has regular income and whether that regular income after the payment of their expenses is enough to support their plan. Let me see here. On Schedule I, you start with your employment, with the debtor's employment status, occupation, and then you go on to disclose their income and any of the deductions from their income that the employer withholds. So you want to look at their pay stubs to fill these portions out. And the same for debtor too. Notice here that on this schedule, you have the possibility of amending your filing or supplementing your filing. That's because in a Chapter 13, again, you're looking at a 3 to 5 year plan. So before the case is closed, the debtor's income can change up, down, hopefully upwards, but possibly downwards. And there may be a requirement to disclose their new income. And so if you're supplementing it, you want to, rather than amending it, you're going to check the second box and the date of the change in income. Again, Schedule I is all income, all sources of income, alimony, child support, wages, business income, rental income, any support payments from anyone, parents, relatives, whoever's helping you with your monthly expenses. And Schedule J is your expenses. Once you have your income on Schedule I, on Schedule J, you will deduct your expenses, and the resulting amount, say it's $300, is oftentimes going to be what you can afford to pay in a Chapter 13 plan. And so while you may find a debtor who wants to keep their payments low at $300 a month, that will probably be fine, but that $300 a month has to be enough for everything that the debtor wants to achieve in their plan. So that $300 a month may not be enough if the debtor is behind $150,000 in their mortgage payments. That number needs to be bigger. So they have to show that they have the means to make the payments that are required by the plan. And conversely, that the amount they're paying into the plan is enough to show that they're paying what they can afford to pay to their unsecured creditors. Statement of financial affairs, I'm going to touch on really quickly. This statement of financial affairs, like the schedules, is filed in all bankruptcy cases, not just Chapter 13. But it basically asks you additional questions about the state of debtors' finances. This is where you're going to, mark whether the debtors are married or the debtor is not married. Past addresses, which is something we use to see if you've filed in the proper venue or what exemptions your client may be entitled to. Past income. So if you have an individual who has very little income now, because they took some time off or they've been laid off recently, but up to a couple of years ago, they were making $150,000 a month, a year. You want to put that, this is where that information goes. And please remember that everything that the debtor is putting on their schedules and statements is under penalty of perjury. So please encourage your clients to be truthful and disclose information accurately. If they're involved in any litigation, that information goes on the statement of financial affairs. If they've made any payments to any of their creditors recently, that information goes on the statement of financial affairs. And then there's going to be obviously other, it's a long form, I'm not going to lie, but then business information is also going to be disclosed here. I want to say something though about like, if you're reluctant to enter a bankruptcy practice because of all the forms, I think the forms actually make bankruptcy practice really easy because it's just fill in the blank. It's the number and volume of forms that are potentially may scare someone off, but if you, there are so many software providers that make this easier for attorneys to practice. So you basically fill in the information once, and then the forms can be, and then the software will auto-populate most of the forms for you, except for the plan. So I would invest in software, and I don't think their prices are outrageous or anything like that, but obviously that's going to be up to the individual firm to decide which software is right for them. The practitioners in Hawaii oftentimes use Jubilee, Best Case, and there might be a couple of others out there, but does make this process a lot easier and a lot less time consuming. This Chapter 13 means test is going to be one of the more important forms your clients have to file. This is where the commitment period of the plan is decided. And by operation of the law again was that there were some amendments to the bankruptcy code back in 2005 that made this test a requirement for Chapter 13 debtors. The first portion of the form 122C1, is going to determine the commitment period of the plan. So the commitment period can range from 36 months to 60 months. And what you'll find is that once you fill out this form, if your client's annual income is above the jurisdiction you're filing in, then their required commitment period is going to be 5 years. That means they'll have to propose a 5-year plan. If their income is below the jurisdiction's median for their family size, then they can propose a 3-month plan. Excuse me, a 3-year plan. So 36 months to 60 months is the range you're looking at. The only exception is if your client or debtor proposes a plan that's 100% planned, then you can go shorter than the required period, but you're going to have to pay all claims 100%. So if your client can achieve 100% payment in the next 12 months, 24 months, then you can propose a shorter term plan, but you will find that that's not possible for most clients unless they have an asset that they're selling, or they're waiting for an inheritance, or like some sort of windfall. The form is very detailed, and you'll find all the information in there. But basically, the gist of it is that the line 2, you'll average the debtor's income for the past 6 months. So basically, you take the debtor's everything earned in the 6 months up to the time they filed for bankruptcy protection, and add it up, divided by 6, and there you have your gross wages and salary. Same for alimony, line 3, all amounts from which, and 4 is any other type of income. 5 would be income from businesses or professions or a farm. 6 is cut off here, but that's rental income. You'll go on to fill out the form, and at the end of Form 122C1, after you've finished filling it out, you'll find whether your client is above the median or above the jurisdiction's median or below the jurisdiction's median. If they are above median, you'll have to fill out Form 122C2. 122C2 will have deductions based on, so remember on Schedule J, you use the debtor's actual expenses as their deductions from their income. On Form 122C2, you're limited to the national or local IRS standards for their household size. So if it's a couple who filed with, and they have 1 child, their household size is 3, and you're going to look for the IRS standards for a household size of 3 for their allowed expenses. So their food expenses, mortgage or rental expenses, those are going to be national. There's some expenses that are local expenses. Again, you'll find those in the IRS standards. At the end of Form 122C2, you find yourself at line 45. And that will be, the resulting number there is going to be your client's disposable monthly income. This is the income. So the number here, let's say in this case, it's $200 multiplied by the commitment period. Since your client is over this jurisdiction's median, the commitment period is going to be 60 months. Less any remaining attorney fees. So let's say your firm represented the debtor. You're opting to receive the $4,000 no-look fee, and you receive the $2,000 retainer, and the rest is going to be paid through the plan. Then you will deduct the remainder here. So $12,000 minus $2,000, you're left with $10,000. The plan over 60 months has to result in payment of at least $10,000 to non-priority unsecured creditors. It's not that hard. We'll walk you through it. You'll find your trustee's office is very helpful in pointing things out and guiding you through this process. But again, I think once you get your feet wet with a few cases, you'll find it to be not so bad. And I already alluded to it. I think the no-look fee currently for cases filed in Guam are $4,000. And unfortunately, I don't have the information handy for the Northern Mariana Islands. But if you're interested, please send us an email at info@hi13trustee hi13trustee.com, and we'll get you that information. And remember, just because there's a no-look fee doesn't mean you have to take the no-look fee for representing your client. You might find it that the case is, you may expect the case to be more complicated than your average case. What you can do then is to file a fee application, and I think you'll find a form for that in one of the forms that was sent today. I'm sorry, that was it's in the forms packet, which the Guam court has so nicely packaged together. This is a continuation of the means test. This is the so-called landing adjustments. So remember on 45, we came out with the dollar amount, and that was $200 a month. On line 46, you can do what's called a landing adjustment, and landing refers to a Supreme Court case from maybe 10 or 12 years ago, where the Supreme Court stated that this mechanical approach doesn't work in every case, and there are if there are changes, known or virtually certain changes to debtor's income or expenses, the bankruptcy court has the discretion to take them into account. So, for example, if your client was earning a certain amount of money the prior 6 months, but was for whatever reason demoted and has now receives less in income, then you want to include that information in line 46 so that the court can take that into consideration when you propose your plan. If the plan doesn't actually pay what the $200 a month or whatever the requirement would be. Whatever the required payout would be to the unsecured creditors. I'm going to take a look at the Chapter 13 plan for the District of Guam. The Chapter 13 plan is very similar to the Chapter 13 plan adopted by the District of Hawaii. I would urge you and your staff to carefully read each and every section of the plan. Everything you need to know to practice bankruptcy is in the forms and in the plans. There's the bankruptcy code too, but everything that you really need to know is already in the forms and the plans because there's references from the bankruptcy code in the forms and the plan. So in this case, section 2, I'm just going to use some highlights. Again, here, notice that you can have amendments to the Chapter 13 plan. So once you file a plan, you're not necessarily bound by it. You can give it a second shot, a third shot, and as many shots as the court will permit before the case is dismissed. Section 2 of the plan is where you lay out the monthly plan payments. So in the case of a Chapter 13 debtor whose household income is under the jurisdiction's median, the debtor can propose a 36-month plan. That dollar amount will typically come from the last line of Schedule J, which is your income minus your expenses. So I minus J is typically going to be what your client can afford in monthly plan payments, followed by the number of months. So if your client can fund the plan in 36 months and is under the median, then it would be something along the lines of, for example, $300 a month times 36, followed by the total, and then that will be the total funding. The duration of the plan is going to be 36 months, but it can be anywhere from 36 to 60 months, depending on the plan proposed. And here is the hypothetical liquidation that we keep referring to. So remember, under this plan, under your Chapter 13 plan, the dividend or the percentage paid, the percentage of your unsecured debt paid has to be higher than a hypothetical liquidation in Chapter 7. So the number following under this plan should be higher than in Chapter 7 liquidation. Section 2.3 of the plan requires each debtor to file their income tax returns annually and provide copies to the trustee's office within 14 days after filing the returns. This is oftentimes an overlooked provision of the plan that results in trouble for the debtors because you have the debtor may go 2-3 years or the entire length of the plan before they actually get copies of their tax returns and turn it over to the trustee. The problem is that your refunds have to also be turned over to the trustee. So unless you turned over your tax returns, you wouldn't be notified as to how much or what portion of your tax refund should be paid into the plan. And so you may end up after 3 or 5 years of making your monthly plan payments with a balance due in the thousands of dollars that it's going to be very hard to make. And if you can't make it, oftentimes that may result in the court dismissing your case. Section 3 of the plan is actually super important because this is where you learn where to put each creditor, okay? So you take your creditors from Schedule D, and all the creditors from Schedule D should be in one of these sections, under secured claims, Section 33.2. there should be, you need to, excuse me. They need to be classified as either 1 through 7, basically. Don't leave any secured creditors unaccounted for in one of the classes. So if it's a secured claim, say a mortgage where the debtor has fallen behind a few payments before they filed their petition, you are looking at class 1 for that mortgage claim because that's a claim where the debtor was in default at the time of the petition and the claimant's rights are not modified by this plan. So what happens is, as a class 1 creditor, that creditor's pre-petition claim, so the missed payments, are going to be paid using the debtor's monthly plan payments. Everything that becomes due after the petition is filed, though, will be paid directly by the debtor. Unsecured claims are either class 8, 9, or 10. Look at the highlighted portion at the top. The proof of claim determines the amount and classification and distribution priority of a claim. So if your client gets it wrong and a claim is not secured, is actually unsecured, then what the plan says is that it will be treated as unsecured, no matter what you have in your plan. If conversely, an unsecured creditor files a secured claim, then you need to go back to the drawing board with the debtor and say, hey, you said that the information you gave me was that this creditor had an unsecured claim, but they claim to have a secured claim. Verify if that's true. If not, you can object to the creditor's claim. If it is correct, though, then you want to go back to the drawing board and amend the plan and provide for that creditor as either class 1, 2, 3, 4, 5, 6, or 7. I'm going to point out some of the more used classifications. This is class 1 again. This is going to be your mortgage claims, any other secured claims where the debtor was in default at the time they filed their case. And by putting them in class 1, you're only curing payments that were made before the petition was filed. So anything missed, any car payments missed, any mortgage payments missed, they are classified as class 1, and Chapter 13 plan payments have to be enough to cover this debt. Make sure you include the interest rate you're going to pay, or the default interest rate will apply. At this time, the default interest rate is 10%. So that makes it more expensive for the debtor to pay back that debt if the default interest rate applies at 10%. If, on the other hand, you think you have a legal basis for proposing a lower interest rate or even 0%, make sure you put it in here so that the default rate doesn't apply. Class 2 is going to be secured claims that you're going to be paying entirely through the plan. So if you have a car payment that you want paid through the plan, this would be where you would put it. If you have a junior mortgage that's come due and it's completely due and payable now, or during the course of the plan, or before the case was filed, it would be appropriate to put the creditor in class 2. Again, remember the interest rate is very important here, because if you don't enter an interest rate, if the debtor doesn't propose an interest rate, the default rate will apply. Class 3 is for claims that you may value under Section 506. So this is one of the biggest benefits of a Chapter 13 case. Say you have a car, and the car was purchased more than 910 days before the case was filed. Well, in a Chapter 13 plan, you can value that claim, value the secured portion of that claim. So let's say the debtor owes $20,000 on it, but the car is not worth more than $10,000 or $11,000. You can propose to pay that creditor back in the secured amount of $10,000 or $11,000, and the remainder will be paid as unsecured. What that means in actuality is, and if your client's eligible for a discharge, and most individuals are, at the end of your plan, once your plan is completed, any unpaid portion of the unsecured portion of the claim will be forgiven. This is the attachment to the plan where you would provide for that creditor. So again, this is the car. Oh, excuse me. I mixed this up. Attorney fee should not be here. Okay. Attachment A to the plan is where you would provide for the class 3 creditor. So you would propose to pay the creditor what the claim is, what the car is worth or the house is worth, rather than what the total balance of the claim is. Section 5.2 of the plan is where you would enter your attorney's fees. So the debtor's attorney, there's two ways for the debtor's attorney to be paid fees from the case. One is to do a traditional fee application with your time records and file it and have it set for hearing, and other parties may exercise their right to oppose it or not, and it'll be granted, and then it'll be paid from the debtor's Chapter 13 plan from the trustee's office every month at the end of the month. Or alternatively, you may choose to use the so-called no-look fee, which would be included here in the plan. So as I mentioned earlier, the current no-look fee is $4,000. So you would start out with the total attorney fees, if you're choosing the no-look fees, of $4,000, less anything paid pre-petition, then the remainder will be paid through the plan. So whatever is left after the plan is confirmed will be paid by the trustee's office to you on a monthly basis until it's paid in full. If the plan is confirmed, section 9.1 says, as soon as practicable after plan confirmation, the trustee will make the monthly disbursements required in sections 4 through 7. So from the debt, so we collect the debtor's plan payments every month. Okay, they're due 30 days. The first plan payment is due 30 days after the petition is filed, and the plan payment amount is whatever the debtor proposes in their Chapter 13 plan. If that plan is confirmed, they'll continue to make those payments for the duration of the plan. From that plan, the trustee takes the statutory fee. That's the fee that is currently 10%, set at 10% of the monthly plan payment. That's what that's how the Chapter 13 trustee's office is paid for and provides the services in turn to the debtor and creditors. Any maintenance payments due on class 1 claims, followed by the debtor's attorney's fees. So in most cases, what happens is from the plan payment of, say, $300 a month, the trustee's fee is deducted. So that's $30, equivalent to 10%. Anything left over will go to the next level of creditors. And in most cases, 99% of cases, that the next level of creditors is the debtor's attorney. So $300 a month, less $30 for the statutory fee, $270 a month. You can expect that $270 a month to be sent to the debtor's attorney, followed by every other and once the debtor's attorney is paid, then the next level of creditors. So that's claims one. I'm sorry, class 1 through 7, followed by class 8, followed by class 9, and followed by class 10. Remember, the monthly payment amount has to be enough to satisfy what you want to do. If you have a car you can't afford, then I suggest you surrender it, because if you can't afford it, you won't be able to make plan payments high enough to pay for the car in the plan. This is just a general timeline of things. Again, in a Chapter 13, you're looking, this process could be anywhere from 3 to 5 years. From the time the petition is filed, schedule statements, unless a motion to, sorry, a petition is filed, hopefully with the schedule statements, the Chapter 13 plan, and all the other required documents. If not, please look into filing a motion to extend time to file the documents. The court may allow you additional time after the petition is filed to file the schedule statements and all the other required documents. About 21 to 50 days later, the meeting of creditors will be held, and that's by Zoom. That's when the trustee will preside over a hearing, often called a 341 hearing or meeting of creditors, and asks the debtor questions under penalty of perjury. The debtor has to turn over certain documents 7 days before that meeting takes place by statute. It has to be by 7 days before. The debtor would have to send the trustee, or you can send them for the debtor, copies of tax returns, the last filed tax returns. So hopefully, if you're filing a case tomorrow, the last filed tax return will be their 2023 income tax returns, copies of their pay stubs for the 60 days prior to filing, a legible copy of their ID and proof of social security number, and a debtor statement, which is form GUB 1007-1B2. Again, all of these are due 7 days before the meeting of creditors. Then, assuming the meeting of creditors is concluded and not continued, the court will hold a confirmation hearing. That would be, I think, according to the bankruptcy code, is supposed to be held 20 to 45 days after the conclusion of the meeting of creditors. At that time, the judge will hear objections to the debtor's case or the debtor's Chapter 13 plan. Oftentimes there are no objections and the plan gets confirmed and everyone goes on about their way, and the debtor will continue to make their plan payments until the plan reaches the end of its term. But if there are objections, then the judge presiding over the hearing will either make rulings or continue for further hearing or a number of other things. But typically, you'll know the fate of the plan at the confirmation hearing. And like I said, if the plan is confirmed as soon as practicable after plan confirmation, that's typically the following month. So if the plan is confirmed in April, then you can expect the first checks to go out in May. The trustee will begin to disbursements of plan payments. And then hopefully this all results in plan completion. The debtor makes timely plan payments for the next 3 to 5 years. The debtor turns over copies of their tax returns every year and pays their tax refund to the plan if required to do so. And what happens is that the plan is then an audit will take place at the Chapter 13 trustee's office, and the Chapter 13 trustee will close the case, followed by filing of a final report. The final report tells everyone that the plan is completed and that these are the disbursements made. Soon after that, unless there's any objections to the final report, I've never seen one, because the trustee never makes mistakes in the disbursements. That's where Karen. The debtor receives their discharge, and soon after that, the trustee is discharged from the case and the case is closed. If, however, for any reason the debtor cannot complete the plan, take a look at Section 1328B. You're not out of options. If you're able to convince the court that the debtor is entitled to a hardship discharge, then even if the debtor wasn't able to make all the plan payments, they may still qualify for a hardship discharge. I can't talk for much longer, unfortunately. But I do want to point out that Section 11.1 of the plan is also really important. That's where all the debtor's duties are outlined. Please have your clients read it and read it over again and make sure they understand all of their duties, including their duty to not incur any debt while they're in bankruptcy, to only pay the creditors that the plan says they're going to pay, file their tax returns every year timely and provide copies to the trustee, among many other duties. If for whatever reason the debtor is unable to make their plan payments, you should expect the trustee to file a motion to dismiss the case. Failure to make plan payments is one of the enumerated reasons in section 1307 of the Bankruptcy Code says is cause for dismissal of the case. But if the debtor believes they have the ability to make up the missed payments, you can but they need more time, you can always try a motion to modify the plan pursuant to section 1329 of the code. Unfortunately, we don't have much time, any time to get into that today, but leave you with some best practices. Always communicate with the trustee's office, keep the lines of communication open. Chances are that we're able to guide you as to what you need to look at or what you need to consider in order to resolve something. Keep the debtor's address up to date so we are able to reach them you know, they get the notices and copies of motions and notices, and they're able to be remain informed of the outcome of their case. And this is for the debtors and creditors. Please check the claims filed by the creditor. You'll get notice of the claims filed. Make sure they're accurate. Make sure that they're provided for in the plan and that it doesn't cause any problems for the completion of the debtor's plan. For example, the IRS will oftentimes file a higher proof of claim than the debtor scheduled them for. Debtors tend to think that they owe a certain dollar amount in past due taxes, but IRS has different ideas. Maybe the IRS is wrong, but unless you check that claim and reach out to the IRS, that claim is going to stand and it's going to get paid, and it may end up in the debtor not being able to complete their plan because their plan payments aren't going to be enough to pay back their priority debt. Are there any questions?
So Nima, I was just curious for future practitioners in bankruptcy. Do you, for example, you have a motion to dismiss that you're thinking of, do you reach out to them first to see if that can be resolved, or what are your like practices with as far as working with debtors counsel?
Typically, when a case is audited and something like that is discovered, so the failure to make a plan payment or some tax returns are past due, we'll email the debtor's attorney's office, and we'll give them an opportunity to reach out to their client and see if it can be resolved before we resort to a motion to dismiss. Usually, we'll track the case for 2 or 3 months before a motion to dismiss is filed. So it's really, we wait to make sure that it's out of absolute necessity because the communication is not resulting in the resolution of the issue.
And one last question for somebody who's completely new to bankruptcy and they may be like stuck on one thing on the form or something like that. And I know, your job is completely different. Are they able to reach out to you just for like a question on general guidance, or that's not something that you do?
Absolutely. Better yet, my staff is so much more well-informed than I am. So they'll probably get through to a staff member first, and if need be, they'll elevate it. But my staff is, knock on wood, the best in the country. And they're also really nice, and they'll guide you through anything you need. And they're mindful of the time difference. So typically, they'll call you back at a reasonable hour. But the best way to communicate for us is always going to be email.
Cool.
So check your emails.
Well, thank you very much.
Yeah, absolutely. Anytime.
Yeah, thank you so much, Nima.
Of course.
We'll
Thank you, Nima.
Yeah, no problem. Nice to hear your voice. Yeah, let me know if there's any questions. I'll happily respond.
Okay, we're going to have a similar session next week regarding Chapter 7 forms and practice. So again, we thank you for helping us out, and we'll be posting this. We'll give you the link so you can see your recording.
Great. Thank you. I look forward to seeing you.
All right, bye.